125. God's property rights. The biblical doctrine of real property is summed up in several verses in the Psalms. The earth is the Lord's, and the fullness thereof, the world, and they that dwell therein. Psalm 24, verse 1. For the Lord Most High is terrible. He is a great king over all the earth. For God is king of all the earth. Sing ye praises with understanding. God reigneth over the heathen. God sitteth upon the throne of his holiness. Psalm 47, verse 2, and verses 7 and 8. The heaven, even the heavens, are the Lord's, but the earth hath he given to the children of men. Psalm 115, verse 16. Very briefly, we are told, first, that God, who is the creator of all things, is therefore the Lord and ruler over all things. We are told repeatedly in Scripture that God regards men as the sheep of his pasture, Psalm 95, verse 7, 100, verse 3, etc. His creatures, and therefore totally subject to his law and government. Neither an atom nor a moment of creation is ever outside his government and law. Second, God has reserved heaven as his throne place, despite his temporary tabernacling in the most holy place of the sanctuary. The earth he has given to the children of men to be used only under his direction and law. Third, this kingly government of God is over covenant keepers and covenant breakers alike. No man can ever step outside God's absolute government. The implications of this are spelled out in the law. Sovereignty means taxing power, hence the tithe. Sovereignty means absolute jurisdiction. Thus, man can use the earth and his own being only subject to God's law. Sovereignty means property rights. The Bible thus affirms the absolute ownership of the earth by God and its possession as a steward by man, under God. The private possession of property is God's purpose, but it is at all times subject to God's law and taxation. For a state to claim ownership over land means thus a direct assault on God's prerogative. State taxation of property, income, and inheritance is therefore, in its essence, anti-God. The claim to have the power to tax is the claim of ownership. This is a fact not commonly recognized. Many taxpayers complain that, in effect, they are merely renters from the state because of their high taxes. They do not recognize that this is in effect as well as in fact the cause. Title to property is title to its use, subject to past, present, and future restrictions, claims, and appropriations by the state. The land, its water resources, and other assets are owned by the state. Hughes has observed, "It would surprise most American landowners today, as it often does those who cannot meet their property taxes, to learn that the state owns the land outright." The origins of this state ownership are in English law from the Middle Ages, when the king was the only absolute, allodial owner of land under feudalism. This concept was later an aspect of the open avowal of the divine right of kings, the origins of which are pagan. The early settlers began with royal charters, which assumed this royal ownership, although the emphasis of biblical law was increasingly in evidence. Chancellor James Kent held that these feudal holds on land were gone in his day, although their legal relics survived. In his Commentaries on American Law, 4 volumes, 1826 to 1830, he stated, "The idea of tenure pervades, to a considerable degree, the law of real property in this country. The title to land is essentially allodial, and every tenant in fee simple has an absolute and perfect title, yet, in technical language, his estate is called an estate in fee simple, and the tenure free and common usage. I presume this technical language is very generally interwoven with the municipal jurisprudence of the several states, even though not a vestige of feudal tenure may remain. In many of the states, there were never any marks of feudal tenure, and in all of them the ownership of land is essentially free and independent. By the Statute of New York of the 20th of February, 1787, entitled An Act Concerning Tenures, the legislator reenacted the Statute of 12 Car 2, circa 24, abolishing the military tenures and turning all sorts of tenure into free and common usage. Under that statute, all estates of inheritance at common law were held by the tenure of free and common usage, but all lands held under grant of the people of the state, and which included, of course, all the lands in the western and northern parts of the state which have been granted and settled since the Revolution, were declared to be allodial and feudal, and to be owned in free and pure allodium. The New York Revised Statutes, which took effect on the 1st day of January, 1830, went the entire length of abolishing the existing theory of feudal tenures of every description with all their incidents, and declaring all lands within the state to be allodial, and that the entire and absolute property was vested in the owners according to the nature of their respective estates, subject only to the liability of escheat. But through the distinction in this country between feudal and allodial estates, either does not exist at all or has become merely nominal, it will be impossible for the student to understand clearly and accurately the doctrine of real property and the learning which illustrates it, without bestowing some attention to the history and character of feudal tenures. Free and common usage was, at the beginning, the only kind of land tenure which the British Crown allowed in the colonies. This form of tenure permitted the owner to inherit, will, lease, rent, or sell the land or portions or assets thereof, but the land was at all times subject to whatever levies, assessments, or taxes the Crown might make against the owner or the land. Failure to pay meant that the stockman, or tenant, lost his land to the donor, the Crown. Because the essential religious principle had become political, stockmanry, or tenant ownership of land from the Crown, had become the legal fact. Instead of the doctrine, the earth is the Lord's. The reality in politics was, the earth is the human king's. Kent is right that in America this concept of tenancy under the Crown had disappeared or become a mere legal relic without meaning. However, the legal precedent was there, in the background, and as statism or centralism began to develop, courts and legislatures quickly seized on that precedent. First, this meant the taxation of land, which more and more states adopted. The taxation of real property today, and of all forms of property, has made stockmanry again a reality. We do not own property. We rent it from the state for a very high fee. Second, the power of the Crown set the precedent for the regulation of commerce. It was at first the states that assumed this power. In Illinois, the states in 1871 passed a law setting rates to control grain storage at public elevators and grain properties. Munn and Scott, owners of a grain elevator, refused to take out a license. The lawsuit, Munn versus Illinois, went to the U.S. Supreme Court, and in March 1877, Chief Justice Waite delivered the majority opinion. He held that the rights of the Crown, which were exercised by Parliaments, had devolved upon the American states, and the medieval and earlier powers to regulate commerce, to set prices for goods sold, and to establish wages, now belonged to the states. Waite cited the existing statutes, either relics or actual regulations, as evidences of this continuing power. Subsequently, of course, the powers claimed in the Munn case by the states were assumed by the US federal government. The extent to which this pagan doctrine has been developed and is in process of being enhanced has been especially in evidence of late in the case of Mel Fisher. Fisher, a treasure hunter and sea diver, located a sunken Spanish galleon, a treasure ship with gold and silver, outside the waters of the US. As a hydraulic engineer, Fisher was successful in coping with the problems involved in raising the treasure piece by piece. But another problem began. First, Florida claimed 75%, then 25%. The Supreme Court soon ruled that the galleon, Atocha, was not in Florida's offshore boundaries. This only set the stage for a federal claim. As Colin Leinster reported it, a flurry of suits and countersuits followed. The US position was that the Department of the Interior inherited George III's, quote, sovereign prerogative over the treasure because it lies on the continental shelf, and that the Antiquities Act of 1906, which gives ownership of artifacts to the government, also applied. The US additionally claimed that it had, quote, control, end quote, over what its citizens, like Mel Fisher, found, whether or not they found it within US territory. The last argument, of course, flaunts the Hague Convention. The origin of all these legal premises is, of course, in the tempter's claim in Genesis chapter 3, verses 1 to 5, that God is not truly God, and that man is a god. It is a claim to sovereignty, and sovereignty is a theological concept. The exclusion of the word sovereignty from the US Constitution has behind it a religious premise, as does the express powers doctrine, which was intended to bar the type of claim made by an ostensibly sovereign power. True, almost at once, implied powers were claimed, but the fact of their exclusion from the Constitution is still true, and the 10th Amendment was designed to emphasize the limitations of powers. The problem is that today, the sovereignty of God is an abstract concept, even to those in the Reformed tradition who most profess it. It does not occur to these peoples that the sovereignty of God has implications with respect to all things, including property, taxation, and the state. Taxation is a prerogative of sovereignty. Modern man has a sovereign, and it is the state. While modern man may complain about the applications of that sovereignty, for example a tax rate or a condemnation proceedings, he does not very often complain about or challenge the principle of state sovereignty. The few who do are anarchists who hold to the sovereignty of man, so that it becomes, with them, a family disagreement with fellow humanists. To regard the sovereignty of God as an abstract concept means regarding God as an abstraction rather than a reality. If we limit God's sovereignty to heaven and the spiritual realm, we are not Christians but Manichaeans. It is a denial of Scripture and of God's emphatic declaration. I am the Lord, that is my name, and my glory will I not give to another, neither my praise to graven images. Isaiah chapter 42, verse 8. For mine own sake, even for mine own sake will I do it, for how should my name be polluted? and I will not give my glory unto another. Isaiah chapter 48, verse 11. The prayer of Asaph and of all saints is that all who in any way, by word or deed, deny God's sovereignty, be confounded. Make their nobles like Oreb and like Zeb, yea, all their princes as Zebah and as Salmunna, who said, Let us take to ourselves the houses of God in possession. O my God, make them like a wheel, as the stubble before the wind. As the fire burneth a wood, and as the flame setteth the mountains on fire. So persecute them with thy tempest, and make them afraid with thy storm. Fill their faces with shame, that they may seek thy name, O Lord. Let them be confounded and troubled forever. Yea, let them be put to shame and perish. That men may know that thou, whose name alone is Jehovah, art the Most High over all the earth. Psalm 83, verses 11 to 18. Oreb and Zebah were Midianite kings who raided Israel in Gideon's day. Gideon captured and killed Zebah and Zalmunna and destroyed Oreb's power. Judges chapter 8, verses 1 to 21. All who attempt to attack God's people and property rights are compared to Oreb, Zebah, and Zalmunna. Their transgressions are against God the Lord. They are attempts to possess God's property. All the nations and all the earth are the Lord's. He is the Lord their Maker, and there is nothing, and less than nothing, in his sight. Isaiah chapter 40, verses 12 to 17. All God's judgment throughout history, culminating in the Last Judgment, are expressions of his sovereignty, his kingship, and his property rights. The beginning of a biblical doctrine of property is to see God's absolute property rights over us and over our income, vocation, family, and total life. What belongs to God cannot be surrendered to another. Our sin begins with a claim that we are our own property, and it ends with our enslavement by a tyrant state. The first step to freedom is to acknowledge that God is the Lord and that beside him there is none else. Isaiah chapter 45, verse 22. It means confessing and declaring, O Lord our God, other lords beside thee have had dominion over us, but by thee only will we make mention of thy name. Isaiah chapter 26, verse 13. It is only the name and sovereignty of God that we will celebrate, obey, and acknowledge as our absolute Lord. Only then can we begin to recapture our freedom from humanistic tyrants and to restore God's property rights and our own freedom under God. There is no other way.